What the new amendments bring is a new regulatory authority, a new agency, and also specialized tribunals to hear matters specifically relating to the regulation of social media content. So the entire Amendment Act is designed in such a way that the Journalists Association and other stakeholders feels, clamps down on free speech and in particular the freedom of the press. So let's just say one of the basis for the government now through this regulatory authority to censor is false and fake information. That's it. So chilling effect is the right word, and it's often used for basically the effect that law can have on people exercising their fundamental right.
Hello and welcome to this episode of the Digi Pod. Today I'm joined by Mian Sami, who is an advocate of the Supreme Court, and he is currently representing the Islamabad High Court Journalists Association. And they have challenged the amendments to the Prevention of Electronic Crimes Act. Thank you for joining us, Sami. Could you please tell us what led to this challenge by the Journalists Association, and if you could take us through sort of the main grounds of your petition?
Thank you, Farieha, for having me. So the Islamabad High Court Journalists Association has challenged the Prevention of Electronic Crimes Amendment Act 2025, which amends the 2016 Parent Act. And so what the government has done through the federal legislature in passing these amendments is to introduce a number of provisions which first establish a new regulatory authority. So previously, under PECA 2016, you had the Pakistan Telecommunication Authority, which would regulate online content, and then also you had the Federal Investigation Agency, which would investigate and then prosecute certain electronic crimes in the 2016 Act. What the new amendments bring is a new regulatory authority, a new agency, and also specialized tribunals to hear matters specifically relating to the regulation of social media content. And it also introduces a new criminal offense relating to the dissemination and publication of fake and false information. So the entire Amendment Act is designed in such a way that the Journalists Association and other stakeholders feels, clamps down on free speech and in particular the freedom of the press. So that's what led to this challenge, and then we can go into it and I can tell you about the grounds as well.
So there are two schemes essentially, right? One on the regulatory side where content takedown is concerned, and then obviously criminalization of fake or false information or news. If we could maybe look at both sort of separately. So beginning with, let's say, the criminal side of fake and false information and how this has been expanded. How does this, what is the view in terms of, like you mentioned, that there's a suppression of speech that is happening on both counts? What are some of the grounds that you've argued, or also, how is this impacting, let's say, Article 19 or even Article 19A for that matter?
Yeah, so in summary, and yes, what our petition does is that it challenges both the provisions relating to the criminalization of dissemination of fake and false information, and also the regulatory aspects, and that is the grant of broad powers to this new regulatory authority. In summary, what we say is that under Article 19, the legislature is only allowed to place reasonable restrictions on free speech, which relate to a number of specific categories identified in Article 19. So, for example, you have the glory of Islam, the integrity, security, defense of Pakistan, and there are other sort of fields of law on which the legislature is allowed to legislate. You have public order, um, and uh, and then there are certain broad terms such as morality and decency, which has always been sort of problematic in terms of how you define those terms. But the law in Pakistan, and this is settled in a number of sort of Supreme Court judgments, is that you can only legislate. First of all, can only place reasonable restrictions through legislation. The government cannot broadly exercise power and censor or remove online content, even if it relates to these categories. There has to be legislation where Parliament sets down, a criteria relating to these aspects, and then imposes, restrictions on certain speech which goes against these interests, so to speak. So the first ground that the petition sets out is that the various provisions don't relate to any of the interests identified in Article 19. So let's just say one of the basis for the government now through this regulatory authority to censor is false and fake information. That's it. There is no identification of what sort of harm needs to be caused through false and fake information. But there is broad power given to this new regulatory authority to simply censor whatever they feel is false and fake information. And that doesn't relate to any of the fields of law identified in Article 19. Then you have the issue that you mentioned, which was the criminalization of dissemination of false and fake information. Now, that provision does set out that if anyone disseminates false and fake information and then it goes on to cause certain type of harm, but again, it's described in very vague terms. So, for example, it uses language such as information that causes or creates a sense of fear, panic, or disorder or unrest in general public or society. Now, that's quite broad. Again, it's subject to abuse, and we've seen in the past, before this amendment, under PECA 2016, that the FIA has been known to investigate and prosecute and harass journalists under the basis of online defamation of certain, political individuals or other public officials. So this is subject to abuse. The petition also then argues that certain other provisions in the Amendment Act, for example, the broad power given to the regulatory authority to direct social media platforms to take down information which they feel is unlawful. That we say is an unreasonable restriction because, again, there is the grant of powers which are too broad, and because the terms in the Act are so vague, it allows this regulatory authority to basically decide on its own whim and fancy what it feels is unlawful. So just the last ground, which is also quite key, is the authority and the tribunal that's been established. The appointment of the members on both of these bodies are entirely in the control of the federal government. But what's more concerning is that even their removal is entirely in the hands of the federal government. There's no security of tenure. And there are grounds of, for example, inefficiency on the basis of which the federal government can simply remove any member. So that causes a problem with the independence of these bodies in making their decisions. And that's something that's also a ground for challenging the Act.
And so, I mean, this used to be a critique even under the PTA in terms of how expansively Section 37 powers were being exercised. But now the way that they have set up this regulatory authority, as you've mentioned, and it's a ground for challenge, is that they function directly under the federal government in terms of notifying and the members and all of that. Plus, do you also see Article 10A or due process and fair trial issues with respect to how, whether on the regulatory side or otherwise, these amendments, because the High Court, typically anything would go to the High Court, but it seems like the tribunal orders are now only appealable before the Supreme Court. And by removing the layer of the High Court, does that also, conflict with any rights?
Yeah. So those are two very important points that you've highlighted that we've also raised in the petition. The first is due process. When it comes to this new regulatory authority making its decisions when it wants to censor, remove online content, the new act provides that anyone can make a complaint, and then the authority needs to make a decision within 24 hours. That does not leave any room for the authority to notify anyone interested in that content, whether the publisher or the social media platform itself. And then what's also interesting is the act goes on to give the chairman of the authority, so one single person, to carry out that emergency action, and then provides for the larger authority to then ratify the decision within 48 hours. So basically, I mean, you're giving a lot of power to one person to make a decision within 24 hours, and then the authority, which is likely to agree to whatever he says within 48 hours, how much of a deliberation can you actually carry out? And then there's no opportunity given to the people who are actually interested in that content. The second thing, like you said, the High Court has been completely bypassed. Now, there are Supreme Court judgments that have previously held that you can't bypass the High Court. The High Court plays a very important supervisory function when it comes to all the courts within a certain territory for each province or the capital territory. I mean, even when it comes to the appointment of members or the chairman, there is settled law which says that the Chief Justice of a High Court should be consulted before a judicial member is appointed as the chairman of a tribunal, because essentially these tribunals perform the function of a court. They exercise judicial power, and so they have to be, one, supervised by the High Court in some sense, and also be completely independent of the government to be able to impartially decide matters.
And so, I mean, clearly there's an issue of lacking independence, and there are due process concerns and excessive speech restrictions. And where is this headed now? I believe that there was an initial hearing. Could you just tell the audience about that? What the next steps with this petition are going to be?
Yes. So earlier, two other petitions were filed by some anchors and another organization. Our petition, when filed, was fixed before the new acting Chief Justice. So he had, because the earlier matters were fixed before another judge, so it was appropriate for him to refer this matter to the earlier judge who had heard the other petitions, and for all of them to be heard together. We had also filed an additional application requesting the court to refer the matter to the Chief Justice to constitute a larger bench, which is essentially, three judges to hear the matter, as opposed to a single judge that typically hears such matters in Islamabad, in the Islamabad High Court. And the reason for that is that previously, in a case with respect to the PECA Amendment Ordinance 2022, there was a decision by Chief Justice Athar Minallah, as he then was, now he's a judge of the Supreme Court, He had held, well, he had struck down the amendment ordinance, and he had in particular held that the criminalization of online defamation was against Article 19. So that's, a binding judgment, that's binding precedent. And so that would bind any other single judge that hears the matter. And so on that basis, we requested the court that it was appropriate for a larger bench to hear this. And the Chief Justice said that that was something that the judge hearing these petitions could assess. And then if there was a need to do that, then that judge could do that.
And finally, what do you anticipate? I mean, given the manner in which this law has been introduced, and we've seen prior to it as well, the prosecutions under PECA, how expansive this law is, especially with respect to, expanding who can be a complainant and the vague sort of terminology, the lack of thresholds, and how are you going to qualify what is fake or false information, and just a complaint can set off the process. What kind of a chilling effect and what kind of impact can it have, not just on journalists, but is also perhaps ordinary citizens who use the internet or social media?
Yeah. So chilling effect is the right word, and it's often used for basically the effect that law can have on people exercising their fundamental right. So even if, there is no direct effect, the existence of this law or any action pursuant to it could, have an effect where people might not be comfortable to exercise their free speech rights, and it would stifle, freedom of expression and freedom of the press. The Amendment Act itself is quite draconian, and you referred to how it also allows complaints to be made by any party as opposed to someone who's actually been affected. Now, there is a new definition of complaint that allows that, but there's also a lot of inconsistency within the Act. So, for example, applications with regard to takedown or removal of fake and false information use the word "a person aggrieved," can file a complaint to the regulatory authority. But again, on the other hand, you have this expansive definition of complaint. So it's not clear, what will happen. But the concerning thing is that there's a broad provision in the Amendment Act which gives additional powers to the regulatory authority. So one argument could be that the authority could still entertain complaints of any sort from anyone. And the other concerning thing is sort of the disproportionate power they have. So, for example, they not only have the power to partially block, a platform, but fully block a platform. And that typically has happened in the past where, some large social media platforms have not cooperated because the demands of the PTA in the past have been unreasonable, and that wasn't aligned with their own policy. And so we've seen YouTube being blocked. We've seen, video games being blocked, and even TikTok, and obviously the recent Twitter or X has been blocked for a very long time.
Absolutely. And X, it's been 1 year since X has been blocked, and there's no sign of it being reopened as yet. And these are exactly the powers that have been written in. Final question, because the government keeps saying that such regulation exists elsewhere. And is this how regulation or regulatory bodies operate in other jurisdictions? Because these claims are made without really qualifying where in the same structure or manner does such regulation exist?
So, regulation of online content is certainly an issue, almost everywhere in the world. There is a recognition that, internet and particularly social media has, created a challenge, especially dealing with misinformation and disinformation, and also something that's called malinformation. which can cause problems for, consumers of online content who just want to know the truth. They can be misled. But in other jurisdictions, there has been a balancing act. So, for example, in the UK, the new Online Safety Act, they also have sort of similar provisions. They've tried to deal with false information, and that has also been criticized by free speech advocates and organizations about, the balance that they've struck. But what's interesting over there is that they've still included and recognized, well, they've included exemptions in respect of journalists and, broadcast news providers, sort of recognizing that, freedom of the press needs to be protected, and there's a certain interest in protecting free speech. But obviously, the balancing exercise all over the world is still taking place, and it's not an easy one. But in the Pakistani context, it's pretty clear to anyone who's familiar with the way PECA has been used in the past and the way this has been designed now, that this is purely to give legal cover to, stop criticism of the government as opposed to anything else, and to sort of have this Damocles sword hanging over independent journalists or anyone, that wants to criticize the government.
Absolutely, and it remains to be seen what happens. We're seeing that journalists are protesting on the roads, and they're calling for a repeal of this amendment and nothing less. We'll see where the court challenges head and what ultimately happens. Sami, thank you so much for making time for DawnNews English. This is all that we have for today.
Thank you for having me.